So, aside from solutio indebiti, the other one is negotiorum gestio. Remember, that is why it is called quasi-contract, because it is lacking of one essential requisites of a contract, and that is there was no consent, and there is no meeting of the minds between the parties, and yet because one benefited out of the act of another person or party, therefore the person who was able to gain benefit has an obligation to pay for damages. So proceeding to a principle of negotiorum gestio, it is definitely refers to managing the property of another person, and that act of managing the property of another person is without the knowledge or consent of the owner of the property, and if by that act of managing the property, he was able to save the property, therefore the owner of that property has an obligation to pay damages. Negotiorum gestio, for example, when a house is on fire, and you voluntary help to save properties of the victim. That is already tantamount to negotiorum gestio, or another example. Joseph went to Palawan to have a vacation without leaving somebody to take care of his pet. Without the consent or knowledge of Joseph, his neighbor Mary took care of his pet and incurred expenses for it, while Joseph is away for nearly 2 months and 3 weeks. Joseph has the obligation to reimburse Mary for said expenses incurred by Mary in taking care of the pet, even if Joseph did not actually give his consent to the act of Mary.